Samuel Morris Reed versus Cars of Nashville, Inc.
We'll hear from the appellant, Mr. Reed.
Yes. On November 8, 2020, I answered an ad on Craigslist by Cars of Nashville for a 2010 Honda Civic. I test drove the car and I decided to purchase it. I asked for the full purchase price for the vehicle, which is supposed to include the cost of the title and registration. I was given all these documents been submitted, vehicle quote price, and based on that, I obtained 2 cashier's checks, paid for the vehicle, and the bill of sale has a cost of $299 for documentation and notary fee. And based on my experience, that should have included title and registration costs. Based on that, I compared it to a bill of sale that I had for my purchase of a vehicle years ago, and that cost was, I don't have a veto. I can't show it. I just submitted. I'll submit the document for that later. The documentary cost on that was $99, and the dealer also paid for they also include the cost for the title and the registration, which when I'm buying a new or used car, I don't handle that. But those $289 didn't conclude the title and registration. That's a lot for copy paper. The bill of sale has an entry for vehicle trade difference. I'm just pointing out some of the discrepancy. That should be a 0. It has $284. He arrived at that based on the price of the vehicle and the $289 in documentary fee. That's how they got that. They inserted a clause right in the area of the bill of sale that's pertaining to trade-in that said that the seller do not title and register the vehicle. Even with that, but based on that, that's where the first, I call this, deception started. And they did not have a small certificate. They didn't disclose it, which it was a requirement in Davidson County. If you want to register the vehicle, you couldn't do it without it. And I always get that to protect myself, have some kind of safety, as is warranty. I insist on having that if I'm going to purchase a used car. So, and I checked I have an OBD scanner, and all the sensors would fail. So if they have the current emission certificate, that would require regular driver about a month before I would be able to register the car, and I would not assume that liability or any cost for that. When about a week and a half later, I received my phone call saying the tag was there. Come pick up the tags. When I got there, at this point, I'm assuming they were going to do the process of tag and registration. After they called me and they told me come pick up the tags, when I got there, I didn't see a plate. So they wanted me to sign something. That's when I asked where was the license plate. That's when I was first notified they don't handle that. So then I asked, okay, do you have the admission certificate? They say they do not. So, and bill of sale doesn't say they're excluded from having that. They cover everything as far as the title has to be free of liens. But my position is, since there was no meeting of the mind, I didn't agree to purchase a vehicle without a small certificate, because I sent some documents to show that around the country that is implied warranted same level as a clear title. So I told the person, the salesman, I'm returning the vehicle because you don't have any of this. I wouldn't agree to the transaction if you had been informed that you don't even have the admission certificate. So I brought the vehicle back all around December 4th. I document the mileage. It don't have been driven to my residence back. So I received the one and only call from someone at the dealer wanted me to sign something again. I think they just want to try to transfer the title in my name, and I wasn't going to allow that. So, and I told my state, I expect you to register the car, I expect you to have a small certificate. So, and then after about 2 weeks, I didn't hear anything. I sent a demand letter, and they responded with a storage bill. I think it's probably around $2,000. They decided to, instead of selling the vehicle to mitigate their damage, they could have sold it for the same price or even higher. They chose not to do that. I contacted, Consumer Affairs, and that said they only title registered as a courtesy. But my position is, I paid for that. There's only so much money I was going to put into the vehicle for his getting it road, worthy for his place in title and registration. So I sent them another demand letter. They responded with another storage bill of about $4,000. So I view this as a form of, intimidation, because people return vehicles all the time. And I figure I return the vehicle with cause. In circuit court, the defense gave testimony for a counterclaim for the storage fees. At that point, it probably around $8,000. I feel I was denied due process because I didn't have the opportunity to refute or prepare for this, a defense for this, because they didn't file a claim in general session court, or a counterclaim at all. So I would have questioned the legality of such a bound for storage fees. I mean, if it was a loan, it would be considered usury. And I can't be expected for me to keep the vehicle probably on the street without a license plate. I don't have a title. It's not registered. But I think that would be the prudent thing for anybody to do. But in circuit court, it was awarded the vehicle. There was awarded for the vehicle, and the cost of it was awarded the payment for the vehicle, and it was awarded the vehicle in lieu of storage fees. And they also stated they offered to register the vehicle, which they could not, because they don't have an admission certificate. In Davidson County, it's a requirement you you can't register without a, some mission certificate, which I provide to Dates and County regulation on that. In closing, I say that the only way to resolve this is rescind the transaction, revoke the sale, and refund my payment, because it's been almost 15 months since the litigation started, and I haven't seen the vehicle, and they precipitated the sale through deception. I think some of the tactics were for the documentation of bill of sales are illegal and unethical, and they're trying to turn a $5,000 car into a $20,000 windfall. I mean, there's puffing, but to facilitate a sale, but to me that goes beyond that, and I spent about additional $1,500 in court costs and expense try to seek justice, because I don't have anything. They have the all of my money and the vehicle. So I understand that, there's no doubt to me that the defense ought to take advantage of the fact that I'm handling the case myself, pro se, but, I didn't ask for this situation. It was thrust upon me, and I have to, one, the right to represent themselves if that situation arises. I think some of the laws was misapplied or sidestepped, and it don't matter if I'm representing someone representing himself or not. The rule of law still apply. And thank you. I believe I hit on the high points that I want to cover today.
Thank you, Mr. Reed. You have your time for rebuttal after the appellee goes. We'll hear from the appellee now.
All right, thank you.
Good afternoon, Your Honors. If it may please the court, Judge McClarty, I'm up pretty close to your alma mater, and the weather here is rough. It is possible that we might lose power this afternoon, so hopefully we'll get through this before that happens. Your Honors, to start with, Mr. Reed is under the obvious misunderstanding about the purpose of this court, that this court is here for him to retry the case on the facts. And as we know, that is not the purpose of the Court of Appeals. Mr. Reed, in his brief and in his oral argument today, has raised no justiciable issue before this court for it to be even properly in this venue. He has raised no issue of law or procedure for this court to evaluate as to merit. Additionally, I will start off with the fact that in the order of the trial court of the circuit court, which was, by the way, the second time that this case was adjudicated in favor of the appellee, that in paragraph or section 12 of the circuit court's order, Mr. Reed acknowledged the order of the court, acknowledged that he had made a mistake, and ratified the judgment of the court, which, as we know from this court's precedent, bars him from an appellate direction. Now, again, I know that our courts do give more leeway to pro se litigants, and certainly Young v. Barrow and other cases out of this court have established that, but nonetheless, pro se litigants must abide by the basics of the procedures of this court. Mr. Reed's brief and his appeal is procedurally deficient on every level. As I stated, there are no justiciable issues raised, no errors of court, no case law cited. He does not cite to the record as to specifics. Again, it basically appears that he wishes to simply relitigate, have another bite at the apple for the third time, on facts that have already been adjudicated twice by very competent courts in our state. So even if there were an issue of merit for the court to review, we don't get to any merit because of the procedural deficiencies and the ratification of the judgment of the trial court. And that would be pursuant to Beasley v. Metropolitan Life. So beyond that, however, if the court were to wish to evaluate the merits, I would say that both of the trial courts that have looked at this case have evaluated the facts, determined that there was a contract, determined that Mr. Reed wanted to withdraw his agreement to a contract in violation of contract law that's well established in this state. So even if the court were to get to merits beyond the procedural deficiencies, beyond the ratification of the judgment of the trial court, the conclusion would be the same, that Mr. Reed entered into a contract, that the courts determined that he, for reasons that we would disagree factually, gave him some justification to withdraw from that contract. Nonetheless, he had contractually committed to the purchase of this vehicle. And as to his claim that the claims for the storage fees should have been a cross-claim or counterclaim, various terms he used, that was certainly brought up in the trial court as a motion for recovery of those fees that is fully justified under the law and case law that was cited at the time. In the circuit court, during the announcement of his judgment, Judge Binkley read from the Beasley versus Metropolitan Life case and explained to Mr. Reed that once one enters into a written contract, if he fails to read the contract or misunderstands the terms, that is not grounds to then withdraw from that contract. So I'm not going to need all of my 15 minutes. I'm simply going to say that I will rest on the brief that in addition to ratification of the judgment of the circuit court, Mr. Reed has failed to bring any issues before this court that are properly here, and that this appeal should be dismissed. Thank you, Your Honors.
Thank you. Mr. Reed, you have your time for rebuttal.
Yes. Whatever happened in general session court, circuit court is another issue. Everybody started the same based on personal experience. I lost two cases, one wage dispute and one is a tenant landlord. I won both in circuit court. One, I got damages, punitive. I acknowledge that the issue for its title and registration, that even though they strategically put it in a spot where it might be overlooked, even with that, there is the issue with the small emission certificate. As I stated, that is implied warranty in that vehicle. If the buyer, if they didn't disclose it, have the right to say, I don't want it. I do not have an affinity for this 2010 Honda Civic or cars in Nashville. I can go to anywhere else and buy a vehicle that dealer will honor what I wish. I have a decision. I have the right to make decision if I want to buy that car without a small certificate. Now, they want to, I'm not trying to rehash, but for that issue with the storage fees, that was not brought up until general session court. I didn't have any notice to dispute that because I want them, which I think they should be required to file a counterclaim with general court, the court clerk, because if they file a claim for $8,000 for a storage fee, I don't think that's legal, and I don't think that the legal system should allow something like that, because
Mr. Reed, Mr. Reed, I'm sorry, but your time, you used up your time here.
okay, I'm done. Go ahead and wrap it up. I appreciate it. Thank you.
That's fine. Let me, Mr. Reed, I'll make sure you, and you may already know this, but I want to make sure you understand the process, the procedure from here. The court will take your appeal under advisement. We'll arrive at a decision and we'll write an opinion and a judgment, and we send the opinion and the judgment to you and Mr. Morris at the same time.
Okay.
Okay, if you would please, Madam Clerk, please recess court till our next scheduled case.
This honorable court is in recess until 2 p.m.
Thank you.
Five,
Five,
4, 3, 2, 1.
This honorable court of appeals of Tennessee is in session.
Good afternoon, counsel. I normally say we don't anticipate any technology-related problems, but apparently with the weather that Middle Tennessee is having right now, we might well anticipate some technology-related problems. But if we do have them, everybody just take a deep breath and we'll pause and work through it. We'll hear from the appellate now.
May it please the court. My name is Mary Beth Hagan, and I'm here on behalf of the appellants, Wilson Bank and Trust and KW Group, LLC. This case starts with a real estate development. Our predecessor in interest purchased property, and in order to subdivide the property for a neighborhood, the local utility district required that the developer deed over enough land for a step wastewater sewer system. And so that happened with the predecessor in interest. What went wrong is that the legal description in the deed included more land than was needed for the step sewer system. Everybody agrees to that. The construction drawings and the plat show part of this land as open space and HOA clubhouse space. All of that was mistakenly deeded to CUD in that warranty deed. And CUD has since taken the position that they cannot return what I will call the excess land unless the developer pays for it. So this case ensued, and in this case, the parties realized that there were a number of agreed upon facts. So the parties approached the judge at the time with a procedure to put forward the stipulated facts and see if the judge could make a ruling. From the appellate's standpoint, the issue was this idea from CUD that they had to receive consideration in order to transfer back the excess land that was mistakenly deeded. And you can see that from what the appellants filed first. But what they did was presented to the judge, let's show you the stipulated facts. We will each submit a brief at the same time, and then we will each submit a response brief simultaneously as well. When the appellants filed their first brief, you could see it in the record. It focuses almost entirely on the statutory framework 782-309 that deals with CUD and its board conveying real property. And our goal was to try to overcome this idea that CUD had to be paid in order to return the excess land. We also filed at that time an affidavit of Mr. Knox, who was with the developer KW Group LLC, and there was a motion to strike. By that point, there was another judge on the case, and we understand things happen. And certainly here in Rutherford County, we have had several cases where multiple judges have been on that file. This particular case had 5 different judges on the file. So when the third judge was over this case, that's when there was a motion to strike the affidavit. And the third judge interpreted the order that set out their framework in the same way that we did. And let me back up because I didn't address that. With the second judge, when we presented this idea to the judge, there was an agreed order dated November 2019. In that agreed order, it mentions the stipulated fact submission, it mentions the memorandum brief submission, and it mentions the response briefs that would be filed simultaneously. But it doesn't stop there, and that is the crux of the issue. In the November 2019 order, it says, should the court determine that additional information is necessary, the court will inform the parties of the same. So the appellants were proceeding under the idea that if the stipulated facts were insufficient to make a ruling, the court would come back and we would have an opportunity to present other facts that we had that could not be stipulated to. That was the second judge who entered that order. So fast forward, when the third judge was handling the case, that judge entered an order in, I believe it was March of 2020, and referenced the fact that 1, this was an atypical procedure, and 2, that he was reserving ruling on whether to strike the outside affidavit until the court reviewed to decide if additional facts were needed. It was ultimately the 5th judge on this file who entered an order, and that judge said no outside facts will be considered. And in the order that we are appealing today, which is from January 2021, that court found on each of the appellant's claims that there were insufficient facts. So there was a need for additional facts. Rather than coming.
Let me interrupt you there, Ms. Hagan, because I think the difficulty with the argument is the trial court's ultimate finding, in my opinion, is not that there were insufficient facts from which the trial court could reach a conclusion, but rather the evidence was insufficient for your client to establish its claim. And I think that's the distinction and the difference. How do you address that?
I would say that there was 4 different positions that the court addressed: breach of contract, which, and then unjust enrichment, promissory estoppel, and then the rescission and reformation. With the mutual mistake or the breach of contract, the court overlooked the warranty deed. That was the contract. And so the trial court found that there was no contract between the parties, overlooking that there's the warranty deed. It is the warranty deed in which contained the mistake. That is the agreement that we were asking to be reformed or rescinded.
And the trial court, did the trial court have that warranty deed, was aware of it?
Yes.
Yeah.
It is in the record. It is part of the stipulated facts, but the court was looking for some other contract. I'm not sure if it was looking for some sort of purchase contract, but there is no other contract. It is the deed, and that is never referenced by the trial judge, even though it's in the record that was before the trial judge. With respect to unjust enrichment, I will tell you, my argument is that the trial court flipped the legal standard for unjust enrichment. All of the analysis is what benefit did the plaintiff receive and appreciate? And that's not the legal standard for unjust enrichment. Unjust enrichment looks at what benefit the defendant, i.e. CUD, received and appreciated, and is it unjust for that party to retain the benefit? So the analysis for unjust enrichment is the primary one where the wrong legal standard was used. With respect to promissory estoppel, in the court's January 2021 order, it was held that an essential element was affirmatively negated, but the element that is referenced is substantial detriment. And so it is not that there's not evidence. If the court found that, to your point, that there wasn't evidence to show substantial detriment, because of the way the agreed order in 2019 was worded, it was our expectation that the framework was the court would not rule against us but would come back and say, oh, I can't rule based on the stipulated facts. And then the parties would have the opportunity to present other facts and to have a trial on the full factual framework. So why did the parties do this? I think it's because in their negotiations, the sticking point was this idea that CUD had to be paid before it could transfer the excess land back. And again, if you look at the appellant's first memorandum that was filed pursuant to the 2019 agreed order, that's what's focused on. That's what they're addressing. You'll see that CUD addressed all of the claims. So certainly everybody wasn't on the same page, but that's the problem with the way this was structured.
Oh, but didn't the order say that if the trial court determined that additional facts were necessary, he'd let you know, or she would let you know?
Yes. And
I mean, and you're saying that you all just anticipated that the trial court judge would say, I need additional facts.
Or would have facts to rule on our claims. But what the ultimate order said was there were insufficient facts.
For you to prove that proved your claim.
Right.
Okay. All right. Let me ask another question, and it may not be necessarily with the issues kind of before us on appeal, but neither of your clients ever paid anything for this property. Is that correct?
Wilson Bank and Trust loaned the money and then went and foreclosed on the property.
But the part of the foreclosure did not include lot 50. Lot 50 was not in the foreclosure. Is that correct?
That's correct. But our client,
So WB&T didn't pay anything at the foreclosure for lot 50.
Correct.
And then they conveyed what they purchased at foreclosure to KW. Correct?
That's right. Yes.
KW didn't pay anything for lot 50 because. So you're asking that this lot 50 be transferred to your clients, even though they never paid, neither one of them have paid anything for it?
The reason is because.
First is your answer yes? Is the answer my question? Okay, now give us the reason.
I'm sorry, Your Honor.
That's okay.
Because when Wilson Bank and Trust took the deed for the property, they succeeded to the role of developer. And then when KW Group LLC took the property, they succeeded to the role of developer. The original developer conveyed this land, lots 50 and 52, to CUD for the purpose of the step system to serve the development. And so reformation also goes to persons in privity of contract. And so because we are successors in interest on the ownership of the development, that's why we're asking to be able to rescind, or I think reformation is probably the better recourse because we know that the step sewer system is needed for the development. That's not disputed. It's just a matter of CUD received much more land than needed. Also, on the unjust enrichment claim, the party asking for unjust enrichment does not have to be the party that paid for it. And so we can show that that CUD received the benefit, appreciated the benefit, and it's unjust for them as a successors in interest. The court could find that it's unjust for CUD to retain that benefit.
What did WB&T buy at the foreclosure? Bankruptcy foreclosure.
At the foreclosure, they bought the rest of the development. So Richmond's retreat.
The property.
Yes. Because WB&T had loaned the money for the purchase.
I understand. So they bought the real estate.
Yes. And then succeeded.
You're saying, and it's your position that buying the real estate puts them in the shoes of the developer.
Yes, through the covenants that are in place.
Okay. Sorry, your time's expired. You have your time for rebuttal. We'll hear from the appellee.
Yes, may it please the court. My name is Roger Hudson. I represent Consolidated Utility District in this matter. This case began with a complaint filed by the appellants and an answer filed by CUD. Mid-Cumberland has never appeared, having been foreclosed upon and apparently in bankruptcy. No written or oral discovery was ever taken in this case. Rather, counsel agreed upon a manner in which to submit the case to the court, as evidenced by that November 21, 2019 agreed order, which was approved by the court. Ms. Hagan was not involved in that. She became involved in the case later. The order was followed to the letter, beginning with the filing of the stipulated facts after weeks of back and forth between the parties to come up with those stipulated facts and stipulated exhibits, which are substantial. And the briefs were filed exactly as ordered by the court. Appellant then filed the affidavit by Mr. Knox, which the trial court found was in violation of the agreed order and contradicted the stipulated facts. The agreed order clearly states that the case will be determined based upon stipulated facts unless the court requested additional information. And we've had a chronicling of different judges for different reasons, retirements and whatever that were involved. But not one single one of those judges ever asked for any additional information. And in fact, Judge Atwood, the circuit judge who ruled in the matter, said specifically that she was prepared to rule on the submissions by the parties as agreed and approved by the court. And in fact, in the appellant's own motion to continue and set filed in the trial court, it stated that if the court believed it could properly decide the matter based solely on the stipulated facts, it would have leave to do so. Well, the court didn't need the appellant's permission to proceed in that manner because that is what was agreed on and put in an agreed order. However, it does show that the appellant knew full well that that was the way this case was going to be presented to the court, and the court had agreed to that. There is nothing novel about the trial court making a determination regarding a case based upon undisputed and stipulated facts and briefs, as I pointed out in my reply briefs at page 18 through 21. Oral stipulations are binding, and certainly where you have months, weeks, at least in months preparing stipulation of facts, those are binding. Neither party had to handle the case in the manner that it did. And the trial court could have said, I'm not going to handle it in that manner. But we agreed to it. Counsel on both sides agreed to it, and we submitted in that manner, and the court signed an order to that effect. Appellant argues that the trial court needed more proof and cites to the court saying that it found insufficient evidence to support their claims. Well, as Judge Davis mentioned, that's simply the court saying you don't have the facts sufficient to support your claim. It doesn't say we're going to stop the matter, go call in new witnesses and let you put on new evidence. If that were the case, anytime a court tried a case, at the end when it found insufficient evidence, somebody could say, well, we need more evidence to come in and try to change your mind, Judge. That was not the way this was ever handled. Every case falls on the sufficiency or insufficiency of the proof. And the trial court making that statement simply means you didn't meet up to the level of proof. The appellants and the appellee, my client, had every opportunity to submit the stipulated facts it thought to present to the court. And it's clear in that order that you should do that, because only if the court asks for more information is there going to be any more information. Now, appellant argues that a promissory estoppel applied, apparently because of some meeting in March of 2014 where CUD talked to the folks at KW Group. But if you'll note, the alleged promise to transfer the property, number one, can't be done by anybody other than the board. And secondly, it wasn't until 4 months later that KW Group bought this property from Wilson Bank and Trust. There's no evidence that there was any check with CUD in between those 4 month period to see if they transferred these lots. And in fact, everybody knew that they didn't. There wasn't any contract to transfer the lots. There was no consideration to transfer the lots. Basically, Wilson Bank and Trust transferred the property that it bought at the foreclosure sale, which specifically excluded these 2 lots, and transferred them to KW Group, again, specifically excluding those 2 lots. The trial transcript did note that CUD could possibly discuss transferring it to these people who had paid not one dime for it, as the court mentioned. If Mid-Cumberland was standing here who had paid money for it, we may have a different situation altogether, but we don't. We have Wilson Bank and Trust who didn't pay a penny for it. Matter of fact, foreclosed on it and bought it in at $900,000 as is shown in the record, and then sold it to KW Group and put a loan on it for $955,000 plus a letter of credit for $150,000. Wilson Bank and Trust has never said that they suffered any loss in this. So we're down to KW Group, and KW Group is the one who has paid not one penny for this and knew what they were buying when they bought it. So they attempt to support this argument with an affidavit which the court found contradicted the stipulated facts, and in its submission in the first place violated the agreed order, which it did. They argue that, well, there should be a reformation because CUD, Mid-Cumberland, and Wilson Bank and Trust weren't aware of what should be transferred. Well, that's not the case. Mid-Cumberland and CUD authorized an engineering report to show what would be cut, what would be transferred, and what was needed. But for some reason, Mid-Cumberland transferred this property to CUD. CUD didn't draw the deed. CUD had nothing to do with the preparation of it. And there's certainly no evidence that CUD committed any fraud to get more property than it was supposed to get. Mid-Cumberland simply conveyed it. They asked for privity. There was no contract between CUD and Mid-Cumberland, and certainly no contract between CUD and KW Group or CUD and Wilson Bank and Trust. So in short, what WBT did, or the bank, I'm sorry, was released its lien on the 2 lots. Mid-Cumberland transferred the 2 lots. The bank foreclosed on the property and sold it to KW Group. There is no evidence.
I'm sorry for interrupting. Can we talk for a minute about the unjust enrichment? Because I do think the trial court's order is a little wonky on this. The trial court in the last paragraph of the order addressing the unjust enrichment correctly cites the law, which discusses appreciation by the defendant of the benefit incurred and acceptance of such benefit under circumstances where it would be inequitable. But then the court says the plaintiff KW is the one who appreciated the benefit, and the plaintiff is the one who accepted the benefit. And then the paragraph concludes by saying, through the acceptance of the deed and payment of the purchase price, defendant KW Group accepted the property. I mean, I think that the court applied it in reverse, as Ms. Hagan said. But I know that you've made an argument that regardless, if it had been applied correctly, it wouldn't apply, basically.
Correct, Your Honor.
Yeah.
The bottom line is, as I've cited in my brief, recovery in an action of unjust enrichment depends upon whether by the receipt of the property in controversy, the defendant was unjustly enriched at the loss and expense of the plaintiffs. And in this case, even if you consider unjust enrichment to Consolidated Utility District, it wasn't at the cost or detriment of either of these plaintiffs. Again, Wilson Bank and Trust has never mentioned any loss by any of this and turned around and placed a lien right back on it. And KW Group wasn't even thought about at the time this was going on and has never paid a dime. So if you come up with an issue of say, well, it might be unjust enrichment to CUD, the only way to quote remedy that is what is being wanted by the appellant. That is just to transfer it to KW Group, who's paid nothing for it. There were some other arguments made, such as a Scribner's error. We went several different places on this. That was never brought up before. It's not in the stipulated facts, and there's no evidence that the manner in which you address a Scribner's error was ever done or even suggested in this case. So finally, just to summarize, Your Honors, is Wilson Bank and Trust had no possessory interest in lots 50 and 52, never paid a penny for it, and they released what interest they had. They've never alleged any financial loss. KW Group did not buy these lots when it purchased the property on July 1, 2014, knowingly. It was clear, they were clearly excluded from the transfer, so they knew they weren't getting them. And they're complaining about way back in March, you told us you might do something. We're here in July. Nobody's ever checked apparently, or if they should have, they knew and clearly was in their deed that they didn't get these lots. So I respectfully submit to the court that the trial court's decision should be upheld. Thank you. Unless you have any questions, Your Honors.
I hear none. Ms. Hagan, we'll hear from you in rebuttal.
Thank you, Your Honor. With respect to the unjust enrichment claim, in the Freeman Industry versus Eastman lawsuit, it says that the benefit doesn't have to come from the plaintiff. Wilson Bank and Trust and then KW Group stand in the place of developer of this property. The restrictive covenants for the development are part of the stipulated facts. And the CUD received what's admittedly more than what it needed for the step sewer system. they only needed the land required for that wastewater treatment system. It's admitted that they received more than that. So that is a benefit that they appreciated. And because of that, the development cannot meet the subdivision requirements for the county. That you can find in the affidavit of Mr. Knox. So we're asking this court to overturn the unjust enrichment claim so that the correct legal standard could be found on that. I think this court could look at what's in the record and find in favor of the appellants on the unjust enrichment claim. With respect to we're not disputing that oral stipulations are inappropriate. I understand that they happen, and I understand that they are binding. And we understand that the agreed order was entered into by everybody. The point is that it didn't end with submit the stipulated facts and submit the written briefs. It went on to say that there was this caveat that if there were additional facts necessary, the court would come back. In the court's January.
We talked about this, but that's not the exact language it said. Didn't it say that if the court determined?
Right. I guess what I'm saying, Your Honor, is that because this is de novo review, I would ask you to determine that was an incorrect determination by the trial court.
That the facts were sufficient for you to recover, for your client to recover? No,
that the determination that there were insufficient facts and not to go back to the parties. Let
me ask you that, counsel. What was the point of submitting this on stipulated facts? If these were just stipulated facts that were to be part of a trial? Because as I understand your argument, if the trial court finds you didn't meet your burden to prove your claims, you say, okay, we get to present additional facts. And I guess the converse would be is if the defendant loses, the defendant would be free to say, oh, now we want to submit additional facts. Is that right?
I think that it certainly leaves that question open. I was not trial counsel.
I understand.
What I've determined in looking at the record is that there was a sticking point on the issue about CUD's authority to transfer back the property without receiving consideration. And you could see that that's where the appellate's head was, because that's what their first brief focused on. That's the only thing I can understand is the parties said, here are the stipulated facts, and the appellants were hoping the court could decide that issue, and then they could proceed from there.
Thank you, counsel. The court's thanks to counsel for both sides. We appreciate your oral arguments today and your briefs, and we're glad that we had no technology-related problems once we got started. So if you would please, Madam Clerk, please recess court till our next scheduled case.
This honorable court is in recess until 3 p.m.
Thank you.
Thank you.
Thank you.
Okay, now I can bring it. So, do this. Yeah. Is Rogers the appellant, Angie?
No, Guo is the appellant.
Okay. Mr. Glow, can you please turn your video on? There we go. All right, we'll be live in 5, 4, 3, 2.
This honorable court of appeals of Tennessee is in session.
Before we call the court, we hopefully will not have any technology-related problems. We've had a little bit of few difficulties because of the weather. I think there in Middle Tennessee, which you are about to share with us in East Tennessee. But if we do, everybody just take a deep breath and pause, and we'll work through it and get back on it. We'll hear from the appellant now, sir. You may proceed.
Oh, okay.
Yeah.
Good afternoon, Your Honors. And my name is Xinhui Guo and pro se for this appeal case. As the case original in circuit court is a malpractice case. And the court should find the favor in my argument because as appellant me and it should be granted the motion for continuous summary judgment hearing. And second, the granted, excuse me, should be granted the motion for amendment the case. So the bigger argument in here, and it's a trial court grant the appellee's summary judgment while the discovery is still ongoing, and it's not closed yet, and that's a big problem. And when I received the deposition from the court reporter on January 18th, which is past 6 days from the November 19, and I only have the 12 days to respond to the summary judgment, which is scheduled on January 31st, 2020. So I filed the motion for continuous on the January 21st and ask a court to give me more time to prepare. And there's a strong evidence to support the continuous because the subpoenaed document as a material evidence is still not on file yet. And there's the two deposition not conducted yet. And that's the main reason I ask the court to give me more time and postpone the hearing for the summary judgment. And I think his law, a lot of the continuous when the pleading file, deposition or admission not on file, the judgment should not be rendered for the summary judgment. That's the law, 1501 said. And also the Tennessee Supreme Court adopted the use the same summary judgment the law and same to the federal. Now, federal civil procedure law 56 said a party may file the motion for summary judgment at any time until 30 days after the close of the all discovery, which means all discovery closed. Then either party can file the motion for summary judgment. In this case, it's a production, the document production still ongoing, and the judge, the trial judge still issues the order for the document production after the summary judgment granted to the appellee. And the latest order from the trial court is March 11, 2020, which after the summary judgment granted to the appellee, the court so the big problem here is the court didn't uphold the Rule 56, and also the case law said, and case law Lindsay versus the Miami the case law and the Tennessee Supreme Court the 1985 said the plaintiff should be given 30 days to prepare and respond to the summary judgment for any evidence, before ready on file. That's the case law said. So I do not have this right. My right has been deprived by the circuit court, and the circuit court denies the motion to continue. And on the same day, on January 31st, 2020. So another dispute is appellant should be granted the motion for amend the case. And after appellant received the deposition on January 18 and also the March 18 from the subpoenaed records, I found that there was a more misconduct from the appellee, so which needed to amend the case, and 3 more claims against him, which is the fraud, breach of contract, and defamation. And the last day close the discovery was on March 30, 2020. I filed the motion to amend is April 13, which only 2 weeks later closed all the discovery process. So court here's the motion and the denial. I said the previous already granted the summary judgment. This so to let me to refile the case, it's not give me the right to amend the case. So as that's another things I need the appeal court to hear and to for the there's the case law said excuse me, the case law said the United States case law said Morris versus Slappy on the year 1983, who assessed that the denial of a continuous once continued denial the due process, which means I have my right on due process has been denied by the circuit court, which it's not a fair trial. Now, if I get more time to prepare the summary judgment, and as a result, would be different. And the fair trial is the essential. I need to be treated me fairly and according to the law and the rules. So like the summary judgment. Court grant to the summary judgment. Summary judgment not based on the merit of the case, and is based on the procedure error and the wrong law used to deny the summary judgment and grant to the appeals. And the same thing to the counterclaim. There was a clear record on court and in record which support my claim. There was a contract outside the written agreement, which is a verbal contract and implied contract. That's all in record, but the circuit court denied my request, and granted the appeals summary judgment. And the summary judgment is the big issue the court used to deny my, to grant the appeals summary judgment is based on the appellant didn't respond undisputed fact. Actually, that in the motion for summary judgment did not serve to me, and all record in court approve my claim. And the appellate, has never, proof in court records, and it does not, attempt to prove, he served me. There's 3 ways to prove he served me, but none of the in record he can, show to the appellate court now. And for the summary judgment, there's a, case laws, in the garden, and should be reversed when the wrong law used to decide the summary judgment, which is one of the e-filing. Davidson County Circuit Court e-filing system, and the judge used to grant appeals summary judgment, said that the summary judgment has been served. But actually, that law not effective until the next year, July 1st, 2020, and appellee served his third summary judgment on October 25th, 2019. In that year, this law not effective yet, not adopted by the law yet. So that law not supposed to use to grant the summary judgment. That's the issue. The law not suitable, and the wrong law used. And I think my purpose is just in the to require the fair trial, and the dispute did exist, and the merit should be trialed in the circuit court and the new trial, and appellants ask the court to reverse the trial court orders, and allowing the appellant to amend the case and have the new jury trial. This case is set on jury trial, and Your Honor, yeah, this concludes my argument and on the procedure and substantive issues. Thank you.
You have your time for rebuttal after the appellee finishes. We'll hear from the appellee now.
Good afternoon, Your Honors. John Rogers, pro se. I'm an attorney in good standing before the bar, appearing pro se. I'll endeavor to be very brief, and the crux, if not the entirety of my response, is going to be really just a recitation of my responsive brief. With regard to the alleged error in Judge Brothers not granting appellant's motion for a continuance. Well, actually, I'll start with amending appellant's action. First off, and fundamentally, the appellant, I might refer to him as the plaintiff, in which case I apologize. The appellant has failed to present any legal authority, either in his briefs or in his recent argument, that illustrates where Judge Brothers erred. And this counter argument of mine can be applied to the other alleged issues that the appellant raises on appeal. But specifically, with regard to the denial of the motion to amend, the court relied on the holding in Churn, which is still good law, and the appellant has provided no legal authority that even attempts to challenge that. And in summary, Churn holds that an inquiry, it looks into an inquiry where the movants, in this case, the appellant's efforts to obtain evidence to respond to the motion for summary judgment, the importance of the newly submitted evidence to the movant's case. 3, the explanation offered by the movement for its failure to offer the newly submitted evidence in its initial response to the motion for summary judgment, for the likelihood that the non-moving party will suffer unfair prejudice, and 5, any other relevant factor. And that's found in Harris v. Churn, 33 Southwest 3rd at 742. The trial court examined the allegedly newly produced evidence and determined that the appellant's response to my submitted statement of undisputed material facts, which accompanied my motion for summary judgment on October 25th of 2019, did not constitute newly discovered evidence within the context of Civil Procedure Rule 5406. Essentially, the alleged new evidence proffered by the appellant was not evidence that either he did or should reasonably have been expected to discover subsequent to his deadlines in responding to my motion for summary judgment. Again, the appellant relies on, stated in his argument, that the e-file system was the reliance of Judge Brothers on denying the motion with regard to the service issue, but that is not the story. Going by the order of July 10th, 2020, Judge Brothers found that the appellant was not credible, quote, insofar as his assertions proffered to support his contention that he was not served with a copy of defendant's statement of undisputed material facts. It is clear from the record that said statement was effectively and constructively served upon the plaintiff by three means: U.S. mail, electronic mail, and the Davidson County Circuit Court e-file system. I'm not going to try to get into the minutia of the facts of the case unless your honors have specific questions or would like me to. Suffice it to say is that the appellant has not produced any authority or any evidence in the record that demonstrates where Judge Brothers, where his judgment and his dismissal or denial of appellant's motions rose to the level of reversible error. The courts of our state give trial courts and trial judges a very wide array of latitude to make those kinds of decisions. And I'll briefly touch on the other two elements of the appellant's appeal. And the argument is the same for both of them. With regard to the motion to continue, the crux of the appellant's argument is that he's entitled to at least 30 days from the provision of his depositional record, which he alleges was received in January, a couple of weeks before the summary judgment hearing, approximately 2 weeks, I believe. But the law affords no such specificity. And the reliance of Lindsay, Justice Duarte's, and I apologize if I'm mispronouncing the justice's name, is taken out of context. The respondent has 30 days to reply to the movement's motion on a summary judgment motion. And in Davidson County, you actually have 37 days. Now, my motion was filed on October 25th of 2019, and the hearing for summary judgment was set for January 31st of 2020. That's much more than 37 days. There's no allowance for 30, or in case of Davidson County, 37 days from the receipt of everything that the non-moving party deems could be relevant and is therefore the determinant of when they can or cannot respond to the motion. The motion deadline is 37 days from, or I'm sorry, they have at least 30 days in Tennessee in general to respond. Not, and then the appellant has provided no legal argument or no authoritative sources to challenge that conclusion. And essentially, your honors, the argument for the denial of my motion for summary judgment and the granting of my motion for summary, or I'm sorry, the granting of both of my motions for summary judgment, one for my counterclaim and one against his original claim, my argument is going to be exactly the same. So for the sake of avoiding redundancy, unless your honors have any specific questions, that concludes my argument.
Thank you. I hear none. We'll hear from you, sir, in your rebuttal.
Okay, your honors, and respond first amending the case, and appellant, fully, met the requirement on the case, U.S. Bank versus Tennessee Farmers Mutual Insurance, which is Tennessee appeal court case 2012, which said a previous unavailable evidence become available, which is I discovered the misconduct from January 18, the deposition transcript that is available to me only 12 days. And for the second, for the service from U.S. Mail, I state clearly in the brief, and there's no record. We speak to record, no record in mail, and not right in the email. And the number 3 for the Davidson County e-filing system, which is not in law yet by the October 25th, 2019. And speak to the Lindsay case law. Lindsay case law, I think, is matched the federal law rule 56, which is all the discovery finished after 30 days, you can file the motion summary judgment. In this case, the discovery is still ongoing for another 2 months, after grant to the appeals in the summary judgment. There's more evidence that came out, after is subpoenaed as a record. And the case, I think, almost same to the federal rule 56, which allowed close the discovery after 30 days. Either party can file the motion for summary judgment. So finally, the judge speak to me on the open court said non-credibility. I think this is a personal opinion. There's no basis how this word came out. I speak to all records. I write in brief is in the court pleading. There are no other things that I can escalate. Everything plead in affidavit and the solid record. So I don't know, the judges opinion to me is non-credible. That's I think a personal opinion. Yeah, I finished, Your Honor. Thank you.
Thanks to both sides for your argument. You may already understand, you may already know what the procedure is from here, but let me state it to be sure that everybody is on the same page. Court will take your appeal under advisement and we'll reach a decision. Then we'll prepare a written opinion and a judgment, and we'll send it to you and Mr. Rogers at the same time. So, of course, thanks to both sides. If you would please adjourn court for this session.
Thank you, Your Honors.
Thank
This
you, Your
honorable
Honor.
court stands adjourned.